Standard corporate law relies on shared risk, majority rule, and aggregate boards, but under specific conditions, that standard model fractures. Title 13 of the Revised Corporation Code governs the exceptions. This section dictates the rules for entities driven by dogma, single-person control, and special regulatory mandates. Specifically, it controls three distinct categories of organizations: educational corporations, religious corporations, and one-person corporations, or OPCs. Because these entities operate on specialized rules, they create specific points of legal failure. Effective application requires identifying exactly where they deviate from standard doctrine. In these contexts, general corporate logic is often suspended. Legal analysis must shift toward the specific regulatory and trust-based principles that govern these unique structures. We begin with Section 105. Educational corporations do not run solely on the Revised Corporation Code. They operate on a dual-engine legal system. This is the SLGP rule. Educational institutions are governed primarily by special laws. The general provisions of the Corporation Code act only as a suppletory safety net. If an agency regulation regarding incorporation contradicts a standard rule in the Corporation Code, the agency's specific mandate strictly prevails. Moving to Section 106, the law strips away the usual flexibility of a non-stock board and imposes a rigid architectural requirement for the Board of Trustees. This is the E515 rule. Trustees for an educational institution must strictly sit at exactly 5, 10, or 15 members. The law enforces a staggered term mechanic. Unless stated otherwise, exactly 1/5 expire every year to ensure continuity. If a trustee leaves mid-term, their replacement does not get a fresh 5-year mandate. They serve strictly for the unexpired period of their predecessor. These numerical requirements are absolute. An educational board with 7 or 12 members is legally void, as it fails to meet the mandatory multiples of 5. Section 107 shifts our focus to religion, classifying religious corporations into two strict categories based entirely on the number of incorporators. A religious society is formed by an aggregate body, multiple people. A corporation's soul is formed by exactly one person. Under Section 108, only specifically authorized individuals, a chief archbishop, bishop, priest, minister, rabbi, or presiding elder, can form a corporation soul. The single ecclesiastical head manages the temporalities and estate of the church, but they do so strictly in the capacity of a trustee. This capacity is the critical distinction. The religious head does not own the church property in their personal capacity. Because the corporation's soul exists exclusively to manage the congregation's temporalities, the personal creditors of the bishop cannot attach church assets to satisfy personal debts. To form a corporation soul, Section 109 requires the Articles of Incorporation to contain 4 mandatory declarations regarding authority, internal rules, vacancy procedures, and location. There is a strict territorial limit here. The principal office of the corporation soul must be located exclusively within the territory of the Philippines. Section 110 contains a unique exemption, driven by the constitutional separation of church and state. A corporation soul achieves immediate effectivity. Juridical personality is acquired the exact moment a verified AOI and certified appointment letters are filed with the SEC. Standard corporations wait for the SEC to issue a certificate. A corporation soul can legally bind itself to contracts the very second its papers hit the SEC desk. Section 111 dictates how a corporation soul alienates real property. The general rule is strict. Selling or mortgaging real estate requires an explicit order from the regional trial court. However, if the internal rules of the church already regulate the disposal of property, the RTC is completely bypassed. The church rules govern the transaction. This creates a unique crossover with foreign ownership laws. A foreign national who heads a corporation soul can legally acquire Philippine land because the property is held merely in trust for a Filipino congregation. Under Section 112, succession is seamless. Any vacancy is filled automatically the moment the successor accedes to office and files their appointment. Dissolving the entity requires dual consent. Under Section 113, the head must submit a verified declaration, and they must provide proof of authorization from the institutional church itself. The state respects the autonomy of the religious head, but it protects underlying assets by requiring either internal institutional consent or external judicial oversight. Section 114 contrasts the corporation soul with the religious society an aggregate body like a diocese or a religious order. To incorporate, a religious society must secure the affirmative vote of exactly 2/3 of its total membership. Section 115 shifts the focus from ecclesiastical entities to purely commercial ones, the one-person corporation, or OPC. The analytical hierarchy here is specific. Chapter 3 dictates the rules for OPCs primarily. General stock corporation rules apply only when Chapter 3 is silent. Section 117 confirms the baseline. An OPC requires absolutely no minimum authorized capital stock unless a specific special law demands it. Section 118 outlines the Articles of Incorporation, codifying the legal reality that an estate or a trust can serve as the single stockholder. By stripping away the friction of aggregate boards, the OPC allows a single natural person, estate, or trust to wield total corporate power with extreme legal agility. Sections 124 through 126 establish the nominee and alternate nominee succession system. In the event of temporary incapacity, the nominee assumes power until the stockholder recovers. In the event of death, the nominee holds power until the legal heirs are lawfully determined. The sole stockholder maintains total operational flexibility, retaining the right to change nominees at any time without amending the Articles of Incorporation. Section 128 legally eliminates the fiction of a sole director holding a meeting with themselves. Corporate actions are validly taken the moment a written resolution is signed and recorded in the minutes book. Section 130 introduces a specific vulnerability regarding the protection of the corporate veil. Standard corporations enjoy limited liability by default. In an OPC, the burden of proof is inverted. The sole shareholder must affirmatively prove that the corporation was adequately financed and that assets were kept strictly independent. Failure to prove independence gives the court grounds to pierce the corporate veil, rendering the single shareholder solidarily liable for all corporate debts. Finally, Section 131 provides a seamless conversion mechanism, allowing an ordinary stock corporation to reorganize as an OPC. When that happens, the new OPC strictly inherits all outstanding liabilities of the original ordinary corporation. The OPC trades the safety of aggregate governance for speed. While it maintains a corporate veil, the burden of proving that shield's integrity shifts entirely onto the sole shareholder. Standard corporate governance breaks down when it encounters special regulatory mandates, divine temporalities, and single-actor commerce. Analyzing these entities requires strict conceptual shifts. You must recognize agency supremacy in schools, the trust nature of church property, and the inverted burden of proof in solo ventures. When you face complex legal applications, rely on these core mnemonics to verify the required structure. Mastering Title XIII means understanding that these special entities do not break the law. They simply operate on a highly specialized legal frequency.